Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about the rule in Browne and Dunn. Cases that should have gone to the Supreme Court of Canada, but didn't. The rule in Browne and Dunn is a long-standing legal rule that essentially says that if you intend to put a version of events forward, you are also required to put that version of events to the applicable witnesses during cross-examination. In Wade Morasti's trial, which was for sexual assault, this rule was breached, and there was a number of discussions and submissions at trial about the remedy for the breach of the rule. Ultimately, the judge ruled that one of the witnesses that was called in the course of the trial was given less weight in their testimony as a result both of the breach of the rule as well as some other issues with respect to the testimony. Mr. Morasti argued that the rule in Browne and Dunn was misapplied, and also that the judge erred in conflating that the witness had less credibility when it should have been an issue with respect to reliability or vice versa. The judge confused the credibility and reliability question. And this case raises very important issues. It's been quite some time since the Supreme Court of Canada has had the opportunity to talk about what happens when there's a breach of the rule in Browne and Dunn. There are a number of conflicting judgments from different court of appeals across the country dealing with the specific remedy that could be ordered if there is a breach of the rule in Browne and Dunn and the need to confront witnesses with information that a person intends to lead. And as far as the remedies of the breach of the rule in Browne and Dunn, there are also different conflicting opinions from courts of appeal across the country dealing with what actually constitutes a breach and how far a person has to go in putting their version of events to the witness for comment before alleging their version of events in their case in chief. And unfortunately, the Supreme Court of Canada didn't recognize the way that the law in this area is conflicting, although very minutely, between various court of appeals, which means that a result that would be obtained as a result of a breach of the rule in one province might not be the same result that would be obtained in another province. And criminal defendants across this country are expected to follow the same procedure and have expectations that the same procedure is going to be followed across the country. So the Supreme Court of Canada should have had the opportunity to better clarify what the specific remedies are for a breach and whether and what constitutes a breach of the rule in Browne and Dunn. And unfortunately, it's going to be a lot longer now before we see the Supreme Court of Canada really drilling down on the significance of this issue and the result, if there is a breach of the rule, as far as how evidence that is led at trial is then treated. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Browne for putting together these videos. Please like, subscribe, and share with your friends.